This video is a detailed analysis of important legal news from the Hindu newspaper, November 2022. The first news article is about the Supreme Court's earlier remark on forceful religious conversion in India as a serious issue and affecting the very security of the nation. Forceful religious conversion is considered as a crime under Indian laws. Every citizen has the right to practice and promote religion peacefully, and freedom of religion is a fundamental right guaranteed under Articles 25 to 28 of our Indian Constitution. This right is guaranteed not only to individuals but also to the religious institutions in India. Article 25 of the Constitution says freedom of conscience and free profession, practice, and propagation of religion. This right gives the individuals the freedom to choose any religion of their choice and also includes the freedom to change one's beliefs or religion. Remember, no forcible conversions are allowed under the article, and states have made it a penal offense if a person is converted by force, fraud, or allurement. Also, this right to freedom of religion is subject to public order, morality, and health. This means Article 25 is not an absolute right. It is subject to certain restrictions which include public order, morality, and health. Only after considering these three things, this right can be enjoyed by the individuals. Offences relating to religion are given under the Indian Penal Code from section 295 to 298. Forcible conversions are punishable under Indian Penal Code under sections 295A and 298. Section 295A IPC prescribes punishment for term of 3 years or fine if any person intentionally outrage or hurt the feelings of any class by insulting his religion or beliefs. Similarly, Section 298 IPC prescribes punishment for a term of 1 year or fine for uttering words or making any gestures with the deliberate intention to wound the religious feelings of any person. Coming back to the articles of the Indian Constitution relating to freedom of religion. As we said earlier, this right to freedom of religion is applicable not only to individuals but also to the religious groups in India, and these are specifically mentioned under Articles 26, 27 and 28 of our Indian Constitution. This right under Article 26 is guaranteed to certain religious denominations, which means certain organizations having a distinctive name or having a common belief. They can own property or administer properties in the name of these religious denominations, and this right is also guaranteed under Article 26. Now, Article 27 of our Indian Constitution, which says freedom as to payment of taxation for promotion of any religion. It means no person shall be compelled to pay taxes for the promotion of any particular religion, and the state should not spend the public money by way of tax for the promotion or maintenance of any particular religion. It is indeed important to note that this provision prohibits the state from favoring or supporting one religion over the other, and thereby protecting the very core of our Indian Constitution, that is the concept of secularism. The word secular is mentioned in the preamble of our Constitution and stating India as a secular state. Moving on to the next article, the Union Home Ministry has asked the states or union territories to appoint a child welfare police officer in every police station. This was done by the ministry on the recommendation issued by the National Commission for Protection of Child Rights, that's the NCPCR, in the backdrop of the increasing number of crimes against children under the POCSO Act 2012. Here, the Home Ministry referred to the provisions under the Juvenile Justice Act 2015, which calls for designating at least one officer not below the rank of Assistant Sub-Inspector as the Child Welfare Police Officer in every station. Now we have to know in detail what are the important statutes or acts that are dealing with child-related offences and what are its main provisions. One of the main legislation which was passed in the year 2012 is the POCSO Act, which is the Protection of Children from Sexual Offences Act. Section 2 of the POCSO Act defines all the important terms such as sexual assault, child pornography, penetrative sexual assault, etc. And Section 2 1D defines child. Any person below the age of 18 years is considered as a child as per the POCSO Act. Recently in 2019, amendment was made to the POCSO Act to provide for more stricter and harsh punishments, including death penalty, to deal with sexual offences against children. Another important legislation is the Juvenile Justice Care and Protection of Children Act 2015. This act replaced the earlier Juvenile Justice Act 2000, and the new act made some changes, added some provisions which allowed for the trial of juveniles in the age group of 16 to 18 years as adults. And for that purpose, a juvenile justice board was constituted, which includes psychologists and social workers who will decide whether a juvenile should be considered as an adult or not. A very recent amendment was made to this act in 2021, which includes the adoption procedures in the case of abandoned and orphaned children. A statutory body was established in the year 2007, the NCPCR, or the National Commission for the Protection of Child Rights. This is a statutory body established as per the Commissions for the Protection of Child Rights Act 2005, and NCPCR is under the administrative control of Ministry of Women and Child Development. One of the important schemes which was developed and launched by NCPCR is Ghar Portal, which means go home and reunite, for the sole purpose of restoration of children. NCPCR as a statutory body monitors the POCSO implementation of the POCSO Act, and also it ensures whether free and compulsory education under the Right to Education Act 2009 is being implemented properly. The next news article is about the Uniform Civil Code, the much debated and most discussed topic. The implementation of a uniform civil code is a prominent issue in India, as it always conflicts with the personal laws in India. At present, personal laws are given a special place in India as it applies to a section of people or a group of people or a particular individual based on a religion, faith, or culture. Hence, the Uniform Civil Code is a proposal to make and implement personal laws to apply to all citizens equally, regardless of their religion or any other thing, in matters of marriage, divorce, inheritance, adoption, succession, etc. Article 44 of Constitution says, the state shall endeavour to provide for its citizens a uniform civil code throughout the territory of India. Hence, Article 44 suggests for equal laws and rules for every citizen, regardless of their religion, caste, or tribe. Presently, Uniform Civil Code is given under Article 44 as a directive under the Directive Principles of State Policy. And apart from personal laws, in civil matters, Indian laws do follow the Uniform Civil Code. Remember, as the Uniform Civil Code is given under the Directive Principles of State Policy in Part 4 of the Constitution, and hence it is non-justiciable, that is not enforceable in courts.